Might be ready to start. Okay.
All right, we're just waiting for the public defender and then we'll get started.
Okay. Yes, Your Honor, thank you. It's going to carry on anyway. And she is really great probably for PS12.
Hi, Taylor, how are you?
Good morning, Judge. I'm well. How are you?
Pretty good. Let's see if I can, just in case, I'll make you a co-host. Okay. All right, we'll do Mr. Raymer first.
Mr. Raymer, you'll step right up.
Okay, we're on the docket in 23-01785. That is People of the State of Michigan versus Brandon Raymer. Counsel, your appearance for the record.
Taylor Wicks, Assistant Public Defender on behalf of Mr. Raymer for purposes of arraignment only, who has made application with our office.
All right, thank you. And sir, you are Brandon Raymer?
Yes, Your Honor.
All right. This is the time set for arraignment. I'll read the charges that have been alleged against you and then read you some rights you have in regards to those charges. It is alleged in a complaint filed that yourself, Brandon Michael Raymer, did on or about May 9th, 2023 at 725 West Genesee Street, apartment 1, did in count 1 knowingly possess child sexually abusive material involving a prepubescent child, contrary to the law of the state of Michigan. That's MCL 750.145C, parents 4, parents B. This is a tier offense under the Sex Offender Registration Act. It is a tier 2 offense if the defendant has a prior conviction for tier 1 offense. It is a tier 3 offense if the defendant has a prior conviction for a tier 2 offense. So felony, 10 years and or $50,000. In count 2, did knowingly possess child sexually abusive material involving a prepubescent child, contrary to the law of the state of Michigan. That's MCL 750.145C, parents 4, parents B. So there is a sex offender registration notice. This is a tier 1 offense under the Sex Offender Registration Act. It is a tier 2 offense if the defendant has a prior conviction for a tier 1 offense. It is a tier 3 offense if the defendant has a prior conviction for a tier 2 offense. That's a felony, 10 years and or $50,000. Did in count 3, did knowingly possess child sexually abusive material involving a prepubescent child, contrary to the law of the state of Michigan, that being MCL 750.145C, parents 4, parents B. It's a tier 1 offense under the Sex Offender Registration Act. It is a tier 2 offense if the defendant has a prior conviction for a tier 1 offense. It is a tier 3 offense if the defendant has a prior conviction for a tier 2 offense. This is a felony, 10 years and or $50,000. Count 4, computer using to commit a crime. Did use a computer program, computer system, or computer network to commit, attempt to commit, conspire to commit, or solicit another to commit child sexually abusive material. That being aggravated possession under MCL 750.145C4-A1. It's a felony, 10 years and or $10,000. There's a clause to reimburse government for expense incurred in relation to violation in the manner indicated. It may be a consecutive sentence, may be imposed on the underlying convictions. On count 5, also did use a computer program, computer system, or computer network to commit, attempt to commit, conspire to commit, or solicit another to commit child sexually abusive material. That's aggravated possession for MCL 750.145C4-A1. It's a felony, 10 years and or $10,000. There may be reimbursement to government for expenses incurred in relation to violation in the manner indicated pursuant to Michigan law. A consecutive sentence may be imposed for the underlying conviction. And in count 6, did use a computer program, computer system, or computer network to commit, attempt to commit, conspire to commit, or solicit to another to commit child sexually abusive material, aggravated possession. That's under MCL 750.145C4-A1. That's a felony, 10 years and or $10,000. There may be a reimbursement for government for expenses incurred in relation to the violation of the manner indicated by the laws of the state of Michigan. A consecutive sentence may be imposed for the underlying conviction. There is also filed a fourth offense habitual offender notice. Take notice the defendant was previously convicted of 3 or more felonies or attempts to commit felonies, and that on or about May 30th, 2000, he was convicted of the offense of CSC, criminal sexual conduct in the second degree, in violation of MCL 750.520C in the 16th Circuit for Macomb County. And on or about March 17th, 2009, he was convicted of resisting and obstructing an officer in violation of MCL 750.81D1 in the 16th Circuit Court for the Macomb County, state of Michigan. And on or about March 1st, 2016, he was convicted of the offense of sex offender registry failure to comply in violation of the laws of the state of Michigan in the 16th Circuit Court for Macomb County. Therefore, defendant is subject to the penalties provided by MCL 769.12. That is, penalty is life if primary offense has been as a penalty of 5 years or more, 15 years of less if primary offense has penalty under 5 years. The maximum penalty cannot be less than the maximum term for the first conviction. Sir, do you understand the allegations and the charges that I've just read to you?
Yes.
All right, you have certain rights in this matter, in these felony matters, and I'll read those rights to you, and I'll walk you through those. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond reasonable doubt that you are guilty. You have the right to have witnesses against you appear at trial. You have the right to have the question the witnesses against you. You have the right to have the court order any witnesses that may appear for you in your defense. You have the right not to have the silence used against you, and you have the right to testify at trial if you choose to testify. It is my understanding that you are going to be seeking further representation from the Public Defender's Office. Is that correct?
That's correct.
All right. I have your date of your next hearing in front of Judge Simmons. It would be a probable cause conference on June 23rd, 2023 at 9 a.m. And then a preliminary examination is to follow on June 30th, 2023 at 9 a.m. You understand a probable cause conference is a preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence the identity of the person who committed a felony crime and the felony crime itself. You, of course, would be represented or could be represented by counsel in the matter. You expect to be represented by the Public Defender's Office, who would contest any charges or cross-examine any witnesses brought against you. Do you understand your preliminary examination rights for June 30th, 2023?
I do.
All right. Do you have a current address for the court file, sir?
725 West Genesee, Lansing, Michigan.
West, okay, that's West Tennessee or Tennessee?
Genesee.
All right. That's Lansing, Michigan.
Yeah, 48915.
All right. Thank you. And do you have a phone number that would be a good contact for the court file?
517-402-9744.
Are you on probation or parole?
No.
Are you employed?
Yes.
And where are you employed, sir?
One Stop Pennzoil.
Your Honor,
Yes.
there is an apartment at that address.
And what's the apartment number?
1.
Apartment 1? Thank you. The court will automatically enter a not guilty plea for purposes of this arraignment. Counsel, would you like to be heard on bond?
I would, thank you. Mr. Raymer made representations to me, and as the court has read into the record, he does have some prior criminal history, but it is relatively dated in nature. He also made representations to me that he has no prior failures to appear. He is a long-term Lansing resident, and he is employed here in the area. And as he's already made representations to the court, he was not on probation, parole, or bond at the time this is alleged to have occurred. While I understand this is serious in nature, it does not allege violence of any kind, and I would be respectfully requesting a reasonable bond be set in this matter. Thank you.
Thank you. I've had the opportunity, so if you're able to make bond, I'll set the following bond conditions. GPS tether is ordered with zone verification in regards to Cammie Beef, who's a witness in this matter. Zone notification. No use of alcohol, drugs without a prescription. No out-of-state travel. No contact with the witness in this case, who is Cammie Beef, not to be within 2,000 feet of where the victim lives, works, or goes to school. No assaultive behavior, no out-of-state travel, no contact, no possession of a firearm, and a report to pretrial services within 48 hours upon release. Had the opportunity to see the criminal history. I also have a bond recommendation from the Ingham County Prosecutor's Office that I'll take into account along with counsel's argument. I do have a 2016 failure to comply with the registration that did not end up. That was a plea to no contest to a misdemeanor offense. I have a domestic assault, which was pled guilty to in 2023. That is a misdemeanor domestic violence, and a PPO that was pled guilty to in 2023. And then I have a prior CSC second that appears to be pled guilty to. The prosecutor's office is asking that for a bond for the protection of the public under state of laws of the state of Michigan. Other factors associated with the risk of lethality in domestic assault situation include force or threatened force or acts, escalation of violence, acute depression, or unpredictable and violent mood swings. And the defendant is a registered sex offender and has been deemed non-compliant by the registry. So a money bail amount will be sent. I do have no contact or into contact with Cammie Beef. I will add Gracie Welch to that. So it's Cammie Beef and Gracie Welch. Gracie Welch as part of that no contact zone notification. And I'll make that a part of the order. That is Gracie Welch. Yeah. Also, I'll be ordering that as a part of the other, that no use of electronic devices in regards to the nature of the offense. I'm going to set bond in this matter for public safety and the nature of the offense and criminal history at $500,000 cash or surety.
Wow.
Anything else for the record in docket 23-01785, Ms. Wicks?
No, thank you, Your Honor.
All right. That's all for the record in docket 23-01785. And then we have Damon Kenny.
Good afternoon, Your Honor.
Step right up.
All right. So we're on the record in docket Well, you are Damon Earl Kenny, sir.
Yes, Your Honor.
Okay, counsel, your appearance for the record.
Taylor Wicks, Assistant Public Defender on behalf of Mr. Kenny for purposes of arraignment only. He has made application
All right.
with our office.
Thank you. So, Mr. Kenny, this is the time set for arraignment. I'm going to read you the felony charges that have been indicated against you and some rights you have in this matter, and then we'll go over some of the dates and times, and I'll ask you some questions. It's alleged that on June 10th, 2023, at 1145 Ballard Street, City of Lansing, Ingham County, State of Michigan, that yourself, Damon Earl Kenny, did break and enter or did enter without permission a dwelling located at 1145 Ballard Street, and while entering, present in, or exiting, did commit a larceny. While entering, present in, or exiting the dwelling, was armed with a wooden stick, a dangerous weapon, and/or Perry Lopez was lawfully present therein. Contrary to the law of the state of Michigan, that being MCL 750.110A, parents 2, it's a felony, 20 years and/or $5,000. A consecutive sentence may be imposed for any other conviction arising out of the same transaction. In count 2, did make an assault upon Perry Lopez with a dangerous weapon, to wit, a wooden stick, but without intending to commit the crime of murder, inflict great bodily harm less than the crime of murder. Contrary to the law of the state of Michigan, that being 750.82, it's a felony, 4 years and/or $2,000. DNA to be taken upon arrest. A consecutive sentence may be imposed under the laws of the state of Michigan if the assault was committed in a place of confinement. In count 3, did knowingly or intentionally possess less than 25 grams of a mixture containing the controlled substance of cocaine, contrary to MCL 333.74032A2AV. That's a felony, 4 years and/or $25,000. There's an habitual offender fourth offense notice. Take notice the defendant was previously convicted of 3 or more felonies or attempts to commit felonies in that on or about April 16, 2008, he was convicted of the offense of operating while intoxicated and impaired. Third offense notice in violation of MCL 257-6256D in the 30th Circuit Court for Ingham County, State of Michigan. And on or about September 15, 2010, he was convicted of the offense of controlled substance, delivery, manufacture of cocaine, heroin, or another narcotic less than 50 grams in violation of MCL 333.74012A4. And on or about August 24, 2016, he was convicted of the offense of controlled substance, delivery, manufacture of cocaine, heroin, or another narcotic less than 50 grams in violation of MCL 333.74012A4 in the 30th Circuit for the Court of Ingham County, State of Michigan. Therefore, the defendant is subject to the enhanced penalty of life if primary offense has penalty of 5 years or more, 15 years or less if primary offense has penalty under 5 years. The maximum penalty cannot be less than the maximum term for a first conviction. Mr. Kenny, do you understand the nature of the charges that have been alleged against you?
Yeah, I understand them. I was unaware of them, sir, but I understand them.
All right, thank you. That's the purpose of the arraignment, is to let you know the nature of the charges. Your next hearing date in the matter will be a probable cause conference in front of Judge. Make sure I've got the judge right here.
Oh my God.
In front of myself, Judge Flores. That'll be on June 22nd, 2023 at 8:30, and a preliminary examination in person on June 29th, 2023 at 8:30. A preliminary examination is a probable cause hearing in which the people of the state of Michigan would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You have indicated that you are going to be or wish to make application to the public defender's office in regards to counsel in that matter, and they would be present to cross-examine any witnesses and contest any charges brought against you. Do you understand your preliminary examination rights that you can exercise on June 29th, 2023?
Yes, I understand, Your Honor.
All right, thank you. Do you have a current phone number for the court's file, sir?
517-862-9745.
And a current address for the court file?
909 East Cesar Chavez.
909. All right. So that's the East Cesar Chavez address.
Yeah. Can I ask a question, sir?
You may want to consult with your attorney? If it's as to this, just this process, the answer is yes. If it's towards the facts of the case, you probably shouldn't say anything on the record.
I was just wondering how many charges is it, that's all.
It's three charges and an habitual.
Oh, wow. Thank you.
All right. Are you on probation or parole, sir?
No, Your Honor.
All right. Are you employed?
Yes,
And where are you employed, sir?
at K&M Market.
All right, I'll
Not-
automatically enter a not guilty plea for purposes of this arraignment. Ms. Wicks, would you like to be heard on bond?
Thank you. As the court has read into the record, Mr. Kenny also made representations to me that he does have some prior criminal history, but it was relatively dated in nature. He had no prior failure to appears and was not on probation, parole, or bond at the time. He's a lifelong member of the Lansing community. He does have family here and has been at his job about 7 years. So he does have good ties to the community. With proper bond conditions, the complaining witness in this file could be protected. I would be respectfully requesting a personal recognizance bond in this matter. Thank you.
Thank you. If the defendant is able to make bond in this matter, I'll set the following bond conditions. The GPS is ordered with zone verification and notification. No use of alcohol or drugs without a prescription. No assaultive behavior. No out-of-state travel. No contact directly or indirectly with the victim, in this case, Perry Lopez. So you're to stay 2,000 feet away from Perry Lopez, where he works, goes to school, or his presence. No possession of a firearm. And report to pretrial services within 48 hours. I've had the opportunity to look at the criminal history. I will also indicate there's a bond recommendation that was indicated by the Ingham County Prosecutor's Office. There is an extensive criminal history dating back to 1999. Which would include assaultive behavior, narcotics, at least 3 drunk drivings, another narcotics, which would coincide with the habitual notice. I'll indicate for the record that the prosecution is requesting protection of the public. The crime charge involves violence towards another person. Other factors associated with risk of lethality are the defendant appears to have been very intoxicated at the time and has a long history of substance abuse. They're requesting money bail in regards to the defendant being ordered not to be within distance of Perry Lopez, which we've already ordered, and possess a firearm along with other items. I will accept the bond recommendation requested by the Ingham County Prosecutor's Office and set this at $150,000 cash or surety. Anything else for the record on Mr. Damon Earl Kenny? Ms. Wicks.
No, thank you.
All right, thank you. You're all set, sir. Thank you for your appearance today.
This way. He's getting his paperwork. We're just gonna sign.
Yeah, and I wrote it in there just so I don't forget. But but if you got it. All right. All right, and we're on the record. Next up is Jonathan Troy Barnes. And sir, you are Jonathan Troy Barnes.
Yes, Your Honor.
All right. Counsel, your appearance for the record.
Taylor Wicks, Assistant Public Defender on behalf of Mr. Barnes for purposes of arraignment only, who has made application with our office.
All right, sir, I'm gonna indicate you some of your rights in this matter and the nature of the allegations that have been brought against you. It is alleged that on June 9, 2023 at 720 West Jolly Road, City of Lansing, Ingham County, State of Michigan, that yourself, Jonathan Troy Barnes, did make an assault upon Antonio Sheffrey with intent to rob and steal while being armed with a dangerous weapon, or an article used in fashion in a manner led the person so assaulted to reasonably believe it to be a dangerous weapon, to wit, a knife, contrary to the law of the State of Michigan, that being MCL 750.89. It's a felony or life or any term of years. DNA to be taken upon arrest. That's a life offense. There's also an habitual offender, a fourth offense notice. Take notice the defendant was previously convicted of 3 or more felonies or attempt to commit felonies. That on or about June 24th, 2009, he was convicted of the offense of unarmed robbery in violation of MCL 750.530 in the 30th Circuit Court for Ingham County, State of Michigan. And on or about June 16, 2010, he was convicted of unarmed robbery in violation of MCL 750.530 in the 30th Circuit Court for the Ingham County, State of Michigan. And on or about June 12, 2020, he was convicted of the offense of larceny from the person in violation of MCL 750.357 in the 30th Circuit Court for the Ingham County, State of Michigan. Therefore, if defendant is subjected to the penalties provided by MCL 769.12, life if primary offense has penalty of 5 years or more, 15 years or less. If the primary offense has penalty under 5 years, the maximum penalty cannot be less than the maximum term for the first conviction. Do you understand the nature of the allegations that have been made against you, sir?
No.
You don't understand the charge of assault with intent to rob while armed?
No.
All right. Well, right now the allegation is that you assaulted somebody with the intent to rob while armed. Do you understand that?
Yeah.
All right. You have certain felony rights in this matter, and I'm going to walk you through those felony rights. You have the right to be tried by a jury, to be presumed innocent until proven guilty, to have the prosecutor prove beyond a reasonable doubt that you are guilty, to have witnesses against you appear at trial, to question the witnesses against you, to have the court order any witnesses that may appear in your defense to remain silent during the trial, not to have that silence used against you, and to testify at trial if they choose to testify. You also have the right to counsel in this regard. Do you plan on seeking further representation from the public defender's office in regards to this file?
No.
Okay. Is that your understanding, Ms. Wicks?
He had made application with our office.
All right. So he has made application in regards to that, in regards to further representation. I'll note that for the file. Sir, you are in front of Judge Buchanan for your probable cause conference on June 22nd, 2023 at 8:30. You're also in front of Judge Buchanan for your preliminary examination on June 29th, 2023 at 9:30. A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence the identity of the person who committed the crime and that a crime was committed in this file. You, of course, have the right to counsel. It appears that you've made application to the public defender's office. Do you understand your rights in regards to your preliminary examination, sir?
Yes.
Okay. Do you have a, where's my register of action? Do you have an address for the court file? Would that be the Jolly Road address?
Yes.
So it's 812 East Jolly Road?
Yes.
Okay. Lansing 48910. Do you have a phone number that would be a good contact number for the court?
No.
Okay. Are you on probation or parole?
Probation.
Are you employed, sir?
No.
All right, I'll enter a not guilty plea for purposes of this arraignment. Counsel, would you like to be heard on bond?
Thank you. As you have already read the criminal history of Mr. Barnes into the record, you are aware of it. He made representations to myself that he has no prior failure to appear, but he is a long-term resident and has family in the area. He is on probation and bond out of the 55th District Court. I would be asking for a reasonable bond in this matter. Thank you.
Thank you. If you're able to make bond, I'll set the following bond conditions, sir.
Hey, can you see if you can I don't know the word for it, but see if I can get a PR bond, because I just got out of jail on a PR bond, and I'm trying to.
Your attorney has made an argument on your behalf. If you're able to make bond, I'll set the following bond conditions. If you're able to make bond, GPS's tether is ordered in regard to victim notification and zone notification in regards to Antonio Sheffy. So GPS is ordered. No use of alcohol, drugs without a prescription or marijuana. No assaultive behavior. No out-of-state travel. No contact with the victim, Antonio Sheffy, which means you should stay out of 2,000 feet from where Mr. Sheffy lives, works, or his presence. Not possess a firearm. And report to pretrial services within 48 hours upon if you're able to be released. I've indicated that I've read the CCH in this matter, the criminal history, which dates back, as I see it, to 2009. There is a prior guilty. There's a prior unarmed robbery that was pled guilty to with circumstances. There's an unarmed robbery. There's a larceny person. There's a domestic out of 2013. There is an assault of a prison employee out of 2016. There is a domestic assault out of 2021, which would confirm the fourth offense habitual notice. I do have a recommendation from the Ingham County Prosecutor's Office that for protection of the public, defendant is on probation or parole. Crime charge involves violence towards another person. The defendant was on bond at the time he committed this offense in the 55th District. So a mail bail bond is requested, and then certain allegations that have been covered in the no contact order. Bond will be set at $250,000 cash surety. Anything else for the record, Ms. Wicks?
No, thank you.
All right, thank you. You're all set, sir.
All right, thank you, Your Honor. Thank you.
You too. Can't read my own writing. It's probably a good idea. Can't read my writing. All right. All right, and so we're on the record in docket. This is Vincent Tucker.
Mr. Tucker, you're going to take it on. Take that off your head. Okay, look, take it off your head.
Right here,
Right up to the table, sir.
to the table?
Right. All right, so you are Vincent Elijah Tucker.
Yes, sir.
All right. This is the time set for a arraignment on these misdemeanor charges. Counsel, your appearance for the record.
Taylor Wicks, Assistant Public Defender on behalf of Mr. Tucker for purposes of arraignment. He has made application with our office.
Thank you. Sir, I'm going to read you the allegations that have been made against you in regards to this misdemeanor complaint. It is alleged that on or about June 9, 2023 at 433 East Edgewood Boulevard, Apartment D, City of Lansing, Ingham County, that you did in count one make an assault and or assault and battery upon Nicole Manley, a resident or former resident of your household or an individual with whom you had a dating relationship, contrary to the law of the state of Michigan, that being MCL 750.81 parents 2. The restitution may be ordered in this case if there was damage to the individual's property or physical injury or death to another individual. This is a misdemeanor, 93 days and or $500. A consecutive sentence may be imposed under the law of the state of Michigan if the assault was committed in a place of confinement. There is a second offense notice that goes along with that charge. Take notice the defendant was previously convicted of assaulting or assaulting and battering his former spouse, former spouse, or an individual with he had a dating relationship, an individual with whom he had a child in common, or resident or former resident of his household, or knowingly assaulting a pregnant individual in violation of 750.81 parents 2 on or about June 25th, 2015, and therefore upon conviction will be subject to enhanced sentence under the law of the state of Michigan. There is restitution that may be ordered in the case. This is a misdemeanor, 1 year and or $1,000 with a second offense notice. Also in count 2 did attempt to commit the following listed offense, and in the attempt did act towards the commission of that offense, but failed in the perpetration or was prevented in the execution, contrary to the law of the state of Michigan, that's 750.92, in that the defendant, Vincent Tucker, did attempt to assault, batter, wound, resist, obstruct, oppose, or endanger Officer Kyle McLazick and Officer Alex Slobin, and or Officer Nicholas McBee, a police officer, Lansing Police Department officers that the defendant knew or had reason to know were performing his or her duties, contrary to the law of the state of Michigan, that being 750.81D, parents 1. That's a misdemeanor, 1 year and or $1,000. Mr. Tucker, do you understand the nature of the allegations that have been brought against you?
Is that saying I assaulted a police officer?
They said that you attempted resisting and obstructing.
Okay.
All right. In regards to, and these are both counts 1 and 2 in the are allegations at this point. I'm going to walk you through the following rights in this misdemeanor case. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have witnesses against you appear at trial. You have the right to question those witnesses. You, of course, are represented today for our purposes by Public Defender Taylor Wicks. And it was my understanding you plan to seek additional representation from the Public Defender's Office. Is that correct?
Yes.
All right. Yeah, you have the right to have the court order any witnesses that may appear in your defense at trial. You have the right to remain silent during the trial. You have the right not to have that silence used against you. And you have the right to testify at trial if you choose to testify. You will get notice of your pretrial in this matter. The pretrial will be on this misdemeanor case, will be in front of Judge Ward on July 10th, 2023 at 10:30.
Yes, sir.
Do you have a current address that is other than the victim's?
Yeah, I was currently staying at the 433 address, but I have a 900 Long Boulevard.
Okay, 900 Long Boulevard.
Autumn Ridge, apartment 522.
Autumn Ridge, apartment 522. Is that
Yes,
Lansing,
sir? Lansing,
Okay.
yes. It's like, I believe it's either Lansing or Hope.
And is that a 48911 address?
Yes, sir. Yes, sir.
Do you have a good phone number for contact?
517.
Okay.
492-9683.
Are you on probation or parole?
No, I'm not on any other of them.
Are you employed, sir?
Yes, sir. And I was supposed to be at work today, man, at 11.
Okay. Where are you employed at?
I work at Ellis Tacos in East Lansing.
All right. I'll automatically enter a not guilty plea for purposes of this arraignment. Counsel, would you like to be heard on bond?
Thank you. Mr. Tucker made representations to me that he does have a dated and relatively limited criminal history. He has no prior failures to appear and was not on probation, parole, or bond when this is alleged to have occurred. He is employed in the area and has lived in the area most of his life. With proper bond conditions, the complaining witness can be protected as he does have an address separate from the complaining witness, and a tether could ensure that. I would be respectfully requesting a personal recognizance bond. Thank you.
Thank you, counsel. If you are able to make bond, I'll set the following bond conditions. There's to be GPS ordered in regards to zone notification and victim notification.
I'm gonna lose my job.
No use of alcohol or drugs without a prescription. No assaultive behavior. No out-of-state travel.
Yes, sir.
No contact with the victim, Nicole Manley. So you're to stay 2,000 feet from Nicole Manley,
I understand.
where she lives, works, or her presence.
Yes, sir.
No possession of a firearm.
I don't carry firearms, Your Honor. I just need to get back to work.
Had the opportunity to look at some of the CCH here. It dates back to 1996. There's one controlled substance out of 99. There is another controlled substance out of 2011.
Yes, sir. Yeah, I was
There's
young and dumb.
a 2013 controlled substance.
I was young and dumb. Yes, sir.
And then there is a 2015 domestic assault, which will take the second offense notice. The court will set bond at $5,000, 10%. Anything else for the record for Mr. Tucker, Ms. Wicks?
No, thank you.
All right, that's all for the record involving Mr. Tucker.
I'm about to lose my job.
And then we have a Roy Hudson.
Right up the table, sir.
So, sir, you are Roy Hudson.
Yes, Your Honor.
All right, counsel, your appearance for the record.
Taylor Wicks, Assistant Public Defender, on behalf of Mr. Hudson for purposes of arraignment. He has made application with our office.
All right, thank you. And this is the time set for a arraignment on a PA 53 violation. The indication is, sir, is that you violated your pretrial order by which specifically indicated that you do not use alcohol, and it appears that you were unconditionally released on bond by Magistrate Milmore, and that was a condition of your bond release. Do you understand the nature of the allegation brought against you, sir?
Yes, Your Honor, I do.
All right. So you have the right to a hearing, and in this matter, the hearing will be set by the district court. You'll receive a appearance to appear at that arraignment date. The judge is to be determined. Sir, the computer would indicate you just got put on probation on June 1st. Is that correct?
Yes, 10 months, Your Honor.
All right. Is that address of the Birchfield address still a good address for you?
Yes, Your Honor, it is.
And do you have a contact number, sir?
Yes, Your Honor, 517-763-7281.
All right. Counsel, would you like to be heard on bond in this case?
Thank you, Your Honor. Mr. Hudson does have some criminal history, mostly alcohol related. He has appeared in court. He was successfully discharged from parole. He has been in Lansing for since 1996. As this would be a probation violation, he is on probation at this time. I would be respectfully requesting a personal recognizance bond. Thank you.
Thank you. Well, it appears whatever bond that was set was not successful in regards to this. In regards to the pretrial order, or what looks like it would be a probation violation based on the report and the extremely high level of blood alcohol level in this case. The initial bond was set at 2,000 PR. I'll set this bond at 2,010%. Anything else for the record, Ms. Wicks?
No, thank you.
All right, thank you. You're all set, Mr. Hudson.
Thank you. Thank you, Your Honor.
And then we're on, thank you, sir. And then we're on the record with Mr. Ware. All right. All right, sir, you are Austin Ware.
Yes, sir.
All right, this is the time set for a arraignment on the charges or the allegations that have been brought against you, and I'm going to walk you through those allegations and some rights you have concerning that matter. It is alleged that on May 30th, 2021, oh, I'm sorry, counsel, your appearance for the record.
Taylor Wicks, Assistant Public Defender, on behalf of Mr. Ware for purposes of arraignment only. He has made application with our office.
All right, thank you. It is alleged that on May 30th, 2021, at 106 East Potter, City of Lansing, Ingham County, State of Michigan, that you did make an assault or an assault and battery upon the following person, Charles Potter, contrary to the MCL 750.81 parens 1. There may be a restitution ordered if there was damage to the individual's property or physical injury pursuant to state laws of the state of Michigan. That's a misdemeanor, 93 days, and or $500. A consecutive sentence may be imposed if the assault was committed in place of confinement. And in count 2, did willfully and maliciously destroy or injure vehicle, tires, the personal property of Charles Potter, and the amount of the destruction of injury was 200 or more, but less than 1,000. Contrary to the law of the state of Michigan, that being 750.377A, parents 1, parents C, parents I. It's a misdemeanor, 1 year and or $2,000, or three times the amount of the destruction of property. Mr. Austin, do you understand, Mr. Ware, do you understand the nature of the allegations that have been brought against you?
Yes, sir.
All right. You have certain rights in this misdemeanor, in these misdemeanor charges, and I'll read those to you. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have the witnesses against you appear at trial. You have the right to have the question the witnesses against you. You are represented by Public Defender Taylor Wicks for purposes of this hearing. It's my understanding you intend to seek additional representation on this file from the Public Defender's Office. Is that correct?
Yes, Your Honor.
All right. You have the right to have the court order any witnesses appear in your defense. You have the right to remain silent. You have the right not to have that silence used against you. And you have the right to testify at trial if you choose to testify. The pretrial on this matter will be determined by notice given to you by this district court. Do you have an address or an updated address to get that notice to Mr. Ware?
Yes, sir.
And what address is that?
11596 Lakeola, Lakola Road, Reed City, Michigan, 49677.
That's Osceola County, is that right?
Correct.
And do you have a phone number that's a good contact number?
Yes, Your Honor. Currently it is inactive until I get out of here, then it will be active.
All right.
My phone number is 231 878
231.
878 0434.
All right. Are you on probation or parole?
No, sir.
Are you employed?
Yes, sir.
Where are you employed at, sir?
Rogers Well Drilling of Cadillac. I drill water wells.
I'll enter a not guilty plea for purposes of this arraignment. Ms. Wicks, would you like to be heard on bond?
Thank you. Mr. Ware made representations to me that he does have a very limited criminal history. It's non-public in nature and nothing similar in nature, that he has no prior failures to appear, that he's not on probation, parole, or bond. He has family here in the area, and he's lived in the Michigan area his entire life, as his court hearings, other than a jury trial, could be handled by Zoom. I would be respectfully requesting a personal recognizance bond, as he does have an address separate from that of the complaining witness in this file, and with proper bond conditions, they could be protected. Thank you.
Thank you. Sir, if you're able to make bonds, I'll set the following bond conditions. No use of alcohol or drugs without a prescription. No assaultive behavior. No out-of-state travel. No contact with the victim, Charles Potter.
Your Honor.
You may go ahead, but you may not want to say anything about the facts of the case.
It was a question about the contact between him. He's married to my sister.
All right. So the contact, at least for the pendency of this order, would be 2,000 feet from Charles Potter. Okay, sir?
Okay, I can deal with that, Your Honor. Thank you.
All right. So 2,000 feet from his presence. You can revisit this at the pretrial, but for our purposes now, it's 2,000 feet of the 2,000 feet from Mr. Potter. No possession of a firearms. I've looked at the criminal history in this matter, and there is one prior MDOP, it appears, out of Lake County. I do have some worry that the victim is a shirt tail relative of Mr. Ware in an older case. This case, I will indicate for the record that this case was initially authorized on July 7th, 2021. So with the assaultive behavior and the no contact order in a 2021 case with one prior, I do have some concerns, not major concerns, but some concerns. I'm going to set a low cash bond at 2,000, 10%. So 10% of 2,000 is the bond on this matter. Anything else for the record of Ms. Wicks?
No, thank you.
All right, you're all set, Mr. Ware. You'll get notice of your future appearance at that Lake City address, okay?
It should be Reed City, not Lake City, sir.
Correct. I'm sorry, it's Reed City, it's Osceola County. So the Reed
Yes,
City
sir.
address.
Yes, sir.
All right,
Okay.
thank you. You're all set. Mr. Looks like Yates. All right.
Hello, Your Honor.
Good morning, Mr. Yates. All right, we're just past good morning. We're good afternoon.
Good
All right.
afternoon.
And this is in regards to docket 22-03235. It's people of the state of Michigan versus Stephen Joseph Yates. Will the parties, Ms. Wicks, would you introduce yourself for the record?
Taylor Wicks, Assistant Public Defender on behalf of Mr. Yates. For purposes of arraignment only, he has made application with our office.
Thank you. And they have made application?
Yes.
All right. And sir, you are Stephen Yates?
Yes, sir, Your Honor.
All right. This is the time set for an arraignment in the matter, and I'll walk you through some of the allegations that have been made against you and then indicate your rights in this matter, in this misdemeanor matter. It is alleged that on or about October 16th, 2022, at the offense location of 645 East Jolly, apartment 13, City of Lansing, Ingham County, that yourself, Stephen Joseph Yates, did in count one, make an assault and battery upon Andrea Mae Brandt Ryan. Excuse me, Andrea Mae Brandt Ryan, a resident or former resident of his household and or an individual with whom he had a dating relationship, contrary to the law of the state of Michigan, that being 750.81 parents 2. Restitution may be ordered in this case if there was damage to the individual's property or physical injury or death pursuant to the law of the state of Michigan. That's a misdemeanor, 93 days and or $500. A consecutive sentence may be imposed by the law of the state of Michigan if the assault was committed in a place of confinement. There is a second offense notice. To take notice, the defendant was previously convicted of assaulting or assaulting and battering his spouse, former spouse, an individual with whom he had a dating relationship, an individual with whom he had a child in common, or former or resident of their household, or knowingly assaulting a pregnant individual in violation of the law of the state of Michigan. On or about September 29, 2009, there was a conviction, and therefore this is subject to an enhancement of 1 year and or $1,000. A consecutive sentence may be imposed if the occurrence happened in a place of confinement. Sir, do you understand the charges that have been alleged against you?
Yes, Your Honor.
All right. The pretrial on this matter is set for July 11th, 2023 at 2:00 in front of Judge Buchanan. That's July 11th, 2023 in front of Judge Buchanan. Sir, do you have a current address for the court file for contact purposes?
I am currently homeless. I would like to say that the victim in this case did overdose and pass away back in March.
All right, thank you. Do you have a phone number for the court?
Yes, 517-214-6809.
All right. Are you on probation or parole?
Neither.
Are you employed?
No, sir.
I'll enter a not guilty plea for purposes of this arraignment. Ms. Wicks, would you like to be heard on bond?
I would. And before I'm heard on bond, Your Honor, I would note for the record that as this is a DV second per local administrative rule, this would be reassigned to Judge Ward. So I imagine his court date and time will be moving. Not that that's something we need to deal with now, but I wanted it noted for the record.
All right. So the pretrial would be in front of Judge Ward on July 11th?
No, Judge Ward and Judge Buchanan have opposite city and state days, so it would likely be July 10th at 9 a.m. As all DV seconds in front of Judge Ward are at 9 a.m.
All right, perfect. So it'll be July 10th at 9 a.m. pursuant to the changing of that. Any further comment on bond, Ms. Wicks?
Thank you, Your Honor. Mr. Yates made representation to me that he does have some prior criminal history. He has no prior failures to appear, that he was not on probation, parole, or bond when this is alleged to have occurred. He is a lifelong resident here of the Lansing area and does have family here in the area. If it is true that the complaining witness in the file is deceased, there should be no issue with any sort of no contact order violations. And I would be respectfully requesting a personal recognizance bond for Mr. Yates. Thank you.
Thank you. If you're able to make bond, I'll set the following bond conditions. GPS notification and zone to be ordered. the no use of alcohol or drugs without a prescription, no assaultive behavior, no out-of-state travel, no contact with the victim, in this case, Andrea Ryan. I understand that for our purposes, you may not be able to have any contact anyway, but for the no contact order, it's 2,000 feet. No possession of a firearm. And I don't know about the facts of this case, but I do know there's a prior domestic in regards to this victim. I'm going to set bond at $2,000, 10%. So $2,000, 10% on that file. And then Mr. Yates, we have you on another file. And I'll read the allegations concerning that other file. It is alleged. And sir, once again, you are Stephen Joseph Yates.
Yes, Your Honor.
Counsel, your appearance for the record.
Taylor Wiggs, Assistant Public Defender on behalf of Mr. Yates for purposes of arraignment only. He has also made application in this file.
All right, thank you. I'll indicate that for the Register of Actions. It is alleged that on April 27, 2022 at 645 East Jolly, Apartment 13, City of Lansing, Ingham County, that yourself, Stephen Joseph Yates, did make an assault and or assault and battery upon Andrea Ryan, an individual with whom he had a dating relationship. Contrary to law state of Michigan, that being 750.81 parents 2, to misdemeanor 93 days and or $500. There is restitution if the offense resulted in damage to another individual's property or physical injury or death to another individual. There's a second offense notice that previously the defendant was convicted on September 29, 2009 of assaulting and or assaulting and battering his former spouse, former spouse, someone who he had a dating relationship, or an individual whom he had a child in common, or resident or former resident of his household. That would enhance this to a 1 year and or $1,000. Consecutive sentence may be imposed under the state of Michigan if the assault was committed in place of confinement, and restitution may be ordered if there's damage to an individual's property, physical injury, or death. Mr. Yates, do you understand the nature of the allegations that have been brought against you?
Yes, Your Honor.
All right. In this misdemeanor charge, you have the following rights, and I'll read them to you. You have the right to be tried by a jury, to be presumed innocent until proven guilty, to have the prosecutor prove beyond reasonable doubt that you are guilty, to have the witnesses against you appear at trial, to question the witnesses against you. You are today represented by Public Defender Taylor Wicks. She would be here, and you've made application to the Public Defender's Office in regards to this file. You have the right to have the court order any witnesses appear in your defense. You have the right to remain silent during the trial. You have the right not to have that silence used against you. And you have the right to testify at trial if you choose to testify. Do you understand your trial rights concerning this file, Mr. Yates?
Yes, Your Honor.
And I'm going to indicate that the same address, which is homeless, and phone number be transferred over. Also, that you are currently not on probation or parole, and that you are currently not employed. And then pursuant to Ms. Wick's statement, I would assume, because this is a second offense, that this would also be going to Judge Ward on July 10th at 9 o'clock. Is that correct, Ms. Wicks?
It would be, Your Honor.
All right. So you should receive, the initial notice here says Judge Buchanan, but it would be reassigned to Judge Ward at 9 o'clock on that July 10th at 9 o'clock date.
Okay.
I'm going to enter a not guilty plea for purposes of this arraignment. Counsel, would you like to be heard on bond?
Thank you, Your Honor. I would be making an identical bond argument to the prior file of the limited criminal history, the no failures to appear, no probation, parole, or bond, lifelong residency, and family in the area.
All right, thank you. It is the ruling. So the court would set the following conditions, pretrial conditions, that GPS is ordered with zone notification. is ordered. It may not use alcohol, drugs without a prescription. No assaultive behavior. No out-of-state travel. No contact with the victim, Andrea Ryan. No firearms. And similarly in regards to this case, the bond will be set at $2,000, 10%. Based on the same reasons as previously indicated. So, Mr. Yates, you should be all set. Thank you for your appearance today. Anything else? I think I've run out of files, Ms. Wicks.
I would hope so, because I am out. I would just thank you for your patience this morning. I know I was a little late from some other courts, and I just wanted to thank you for your patience this morning.
No worries. And are you going to be with us tomorrow also?
I will be, and I will be in contact with Ms. Holden. Hopefully we can get on the record a little earlier tomorrow.
All right. No worries. Thank you for your appearance today. We'll see you tomorrow.
Thank you.
Honor.
Bye.
And we're all set, Jail.